Welcome, everybody, to our special industry update this July. Thank you so much for joining us today. I'm Jill Cox. I'm a sales executive with Heritage Title Company, and I am here with my amazing husband, Mr. Damian Cox, Vice Chairman of the Forms Committee. And we have some contracts changes coming around the bend for us. And I'm just going to let Damian kind of dive right in. As Damian had just mentioned, we do expect to have close to 1,000 people on this webinar today. So, and he has a lot of content to try to pack into in an hour. So he's going to just kind of dive right in, go pretty quick, high level through this information. We will try to tackle some Q&A at the very end. But so if you could save your questions for the end, we'll try to get to as many of those as we possibly can. So with that, I'll turn it over to you, Mr. Cox.
Great. So guys, I just want to start with what we're really going to cover today is going to be about the impacts that the NAR settlement had on the contract forms, because I think that's been top of mind for everybody. I will let you know that there were a lot of changes to the contract to buy and sell in addition to those that just affected the that were caused by the NAR settlement. There's no way I can get through all of that stuff in an hour. This is another year, guys. Unfortunately, you're going to have to take a red line contracts class, or at least I'm going to recommend it. What you're going to see as we go through this is that it's pretty dense, some of the stuff, and there's going to be a lot of questions. And frankly, the contracts aren't even in use yet. So come August 17th, when people start using these forms, we're going to see practice changes that the drafters of the forms or the real estate commission or anybody else didn't really even see coming. I mean, that's just the nature of this beast. So please, I just feel like you guys can't hear this too much as far as what's happening and what's going to happen in your industry as you figure out how you're going to navigate it with your business. So please be diligent and take some classes and look at that stuff. And that's not a plea for you to take my classes. I want you guys to be prepared for the changes. Essentially, there are 4 changes that changed with the division of real estate. We have the seller listing contract changed, all NAR settlement changes. Buyer listing contract changed, again, all NAR settlement changes. Broker's disclosure to buyer changed. Again, NAR settlement changes, but we'll get to that one because it's kind of confusing. Because why would we want anything to make sense? And then the contract to buy and sell, we'll talk about the new paragraph 29 that was added because of the NAR settlement. Those are the 4 from the division of real estate. There is one other form that I'm going to actually launch off and talk about, which is brokerage firm compensation agreement. Now, I'm going to go through and kind of talk about some of these practice changes that were the reason for each change as we go. But primarily the biggest change is, I think, unless you've been living under a stone for the last 6 months, I guess, you know that the offer of compensation is the thing that's the biggest change as far as in the MLS. It's going away. There's not going to be an offer of compensation in the MLS. I hear a lot of brokers talking about ways to get around it. Please don't do that. I will call it, I've seen a site now that says brokerage firm compensation aggregator or something like that. Just so you know, this settlement, what it does is it settles out NAR, it settles out realtors, and it settles out MLSs. What it doesn't do is prohibit people from bringing claims against brokers that end up colluding later on to set prices. So you can see where if you have MLS, or I'm sorry, you have a website that's aggregating from other people's websites or putting it on your website, where that could become a problem. So I don't like putting it online. I know that the settlement says that you can put it on your own websites, but I see problems coming from it. And that's just my opinion. Take it for what it is. If you have your own real estate attorney, talk to them about it. But I see that as an issue. I also hear people talking about, well, what we're going to do is we're going to put it on riders and we're going to put it on flyers and we're going to do this and advertise it. Well, the biggest problem with doing that is that it still isn't an agreement. You haven't reached an agreement between the listing broker and the buyer broker as far as what that compensation is. So, and the reason I'm talking about that is because that is where our first form comes up here that we're going to talk about. Originally, it's called a brokerage firm compensation agreement. And originally we wanted or asked that the Division of Real Estate promulgate this form. And the Division of Real Estate said, we don't think that's such a great idea. And so it's like, wait a minute, why not? It would add to standardized form in the industry. It would mean that people, buyers would understand, sellers would understand. It would be good for the industry. And then Marcia Waters said something that made a lot of sense to me. And I said, okay, you're right. What she said was, Damian, if we promulgate that form, first of all, it's between brokerage firms. It's not for the consumer. So I'm not sure we even have jurisdiction to do it. But second of all, if we start weighing in on brokerage firm compensation, does that now mean that we have jurisdiction, or that we should be weighing in on amount of compensation, how they were paid, when they were paid, why they were paid? And I went, no, thank you. And so there is no brokerage firm compensation agreement from the Division of Real Estate for those reasons. So after we got told that that was what was going to happen, Scott Peterson says, Damian, why don't we talk to the bar? And so Carr put together a letter to the Bar Association. If you'll remember, the Bar Association created forms during the pandemic for us. They created the radon disclosures as of the latest ones, and said, hey, Bar Association, would you mind creating a standard form for use by brokers, because we're going to need something. And I'll tell you what Scott and my biggest concern was, is that if we let the brokerage firms or the lawyers create their own forms, could you imagine the turmoil that that would create? You would have all these lawyers creating different forms. I can tell you from my perspective, if I'm a lawyer, I'm going to create one form for when you represent the seller and one form for when you represent the buyer. And that's going to create all sorts of issues. And then all of a sudden you have fights over which form you should be using. So the purpose of the Bar Association's form is to get that consistency, so that the industry has a standard form that everybody uses moving forward. Honey, would you mind putting up we have a QR code to the Bar Association's website. They are allowing you to buy the form. I think it's $40, and a brokerage firm can buy it for all of their brokers. And I'm just going to encourage you guys to get this, because then we have some uniformity in the industry. If you work for Iris, or if your MLS is Iris, I think Iris may be looking at doing a license with the Bar Association for that. If you're my client, I've already done that for you as well. So what is that?
Does that not look right?
It looks like two different ones. I don't know.
Oh.
Anyways, I'm encouraging you guys to do this, because I think it'll create efficiency in the industry if it's just one form. I know that you don't have to do it. You're not obligated to do it. I understand that. This to me makes the most sense. So there is the QR code. If you want to take a picture of it, you can go to it. But I think that's going to help our industry the most if everybody conforms to one standard form for this tool. With that, honey, I'm going to go ahead, if you don't mind putting that in the chat, I'm going to go ahead and share my screen and go through, start going through this form. Oh, but I've been disabled. Can you allow me to share?
I suppose.
She's trying to control me.
I got an error on that QR code too, guys. So we'll dive into that and make sure you get that. Sorry about that.
Yeah, we'll send it out with I guess we should just send it out with the, we'll send it out with the response after this, or with the recording. I didn't check it to see if it worked, because I don't even know how QR codes work. So there is that. I'm old. What do you want from me? Okay, you ready? Okay, so I'm going to dive into this. This is this is the Bar Association's form. I'm going to blow it up so you guys can see it. It's called the Brokerage Firm Compensation Agreement. It was created for use. It's not created by the Real Estate Commission, but it was created for use by the Bar Association for real estate brokers. It has the standard terms in here: who's the seller broker, who's the seller brokerage firm, the buyer broker, the buyer brokerage firm, and the property that we're talking about. And then we go into the agreement. And again, the reason this is important is that it sets forth the agreements under which a buyer broker can receive compensation. One thing I want to warn you about is that if you guys are texting back and forth, oh, are you offering compensation? Yes, I am. This is X percent is what I'm offering. Okay, that sounds great. That's probably a contract. But the issue is that contract between two brokerage firms? Is that between the brokers? What happens if it's a different buyer? What happens if it's a different listing broker that is now selling the property? Is there still a claim against the old brokerage firm? You can create a whole host of messes by not having an actual agreement put together between you guys. So that's why I would encourage you to use this instead of just texting back and forth what agreeing to, because you don't want to create this conflict when something comes up. So I'm going to go through these terms just so you can see how this thing works. It says the seller brokerage firm and buyer brokerage firm are parties to this brokerage firm compensation agreement. Obviously, compensation is paid by the brokerage firms, so that's why they're the parties to it. Seller brokerage firm represents that it is actively engaged in an exclusive right to sell listing agreement with the seller of the property, and seller broker is designated to perform brokerage services on behalf of seller brokerage firm to seller. And then we have the same thing for the buyer broker. Buyer brokerage firm represents that buyer broker is actively engaged in brokerage relationship with a buyer or buyer's successors or assigns interested in purchasing property similar to the property, and that's defined as buyer. Buyer broker is designated to perform brokerage services on behalf of buyer brokerage firm to buyer. Okay, it's setting up the fact that you have these relationships. And then we get to the meat of this. It says the parties agree that upon buyer and seller entering into a contract for the purchase and sale of the property, defined as real estate contract, and successful closing of the sale of the property, closing, to said buyer, seller brokerage firm agrees to pay buyer brokerage firm compensation in the amount of whatever of the final purchase price as described in the real estate contract, or it could be a flat fee. However, buyer broker must tender the real estate contract, and buyer brokerage firm must continue to work with buyer through closing. Okay, so you have these contingencies about how they earn that commission if you're representing the seller. You guys got to tender me an offer. You can't just say, oh, I was working with that buyer and I showed him the property. That doesn't count. And the purpose here obviously is to make sure that the listing broker knows that the offer of compensation they have for that broker is for that contract because the broker has showed up on that contract. I lost my place. Such compensation is earned at the time the real estate contract is signed, and that's because all commissions are earned at the time of contract, but is contingent upon closing, and buyer brokerage firm will be paid by seller brokerage firm at closing. Parties agree to the disclosure of such compensation in the real estate contract and or their respective clients, obviously going for transparency, part of one of the issues that was in the antitrust lawsuits as well as the DOJ. Okay, so that kind of sets up, what has to happen in order for you to have this agreement. This next part has some things about when this thing terminates, because it was kind of a strange, before when we had the offer of compensation, you had the offer of compensation was there as long as the listing was active. The minute it was not active, it wasn't there anymore. But we don't have that automatic mechanism anymore through the MLS. So what this one says is this. It says, this agreement expires upon the expiration of seller brokerage firm's listing agreement, originally naming the seller broker. So in other words, if the seller broker doesn't have the listing anymore and another broker within that brokerage firm gets the listing, this thing's dead. Okay, it only applies to when the seller broker is the designated broker on that listing contract, as well as any extensions thereof or additional rights thereon. However, any compensation earned prior to such expiration will remain due and payable to buyer brokerage firm at closing. Any amendment to this agreement shall be in writing and executed by the parties. So as long as you have it under contract prior to any expiration or anything else, that means that you do get paid on this as a buyer agent. All right. Parties authorize their respective brokers to execute this agreement on their behalf. We're borrowing from the listing contracts. If you remember in the listing contracts, it says that if you're the buyer broker, you're signing on behalf of the brokerage firm when you sign a buyer listing contract, or the seller listing contract on behalf of the brokerage firm when you sign a seller listing contract. So we're borrowing from that the brokers individually can still bind the brokerage firm to this agreement. Like I said, listing brokers, you're going to have to pay attention to these agreements that you send out. And the other thing I want to warn you against, what happens if you fill out this agreement, sign it, send it out to the buyer broker, and they never send it back, and then they bring in a contract? Do you see where all of a sudden you've got problems because you don't, and then after closing, they say, hey, wait a minute, you owe me money? Remember this that you sent me? My suggestion is that, first of all, buyer brokers, I think you could send it over first if you want to. Seller brokers, if you want to send it over, I'd probably send it over unsigned so that the buyer broker sends it back and then you sign it and send it to them. Because you're going to have to keep track of these things, because I see a lot of these fights coming over, oh, did you get one? Did you not get one? When did you send it? Did you send it back showing them that you accepted the offer? Did you, oh, wait a minute, I didn't send it back. And just, be diligent like you would with any other contract. about making sure that you're getting this executed in a timely manner, both parties are signing it, and everybody's on the same page. Because the last thing you want is for there to be conflict over this agreement, because now you're going to end up in arbitration fighting over whether or not there was a commission that was earned under this agreement. All right. I'm sure there's questions on this, but I think I'm going to just keep moving, honey. Does that make sense?
Yep. We'll try to address those at the end, guys.
Okay. I will see if I can get that QR code fixed as well. But I do think at least this outlines, and spend some time with it, go through it, understand it. If you're an employing broker, make sure you're going through it with your broker associates so that they understand how to use it, when to use it, and why to use it. All right. So the next form I'm going to use, or I'm going to pull up, is this is what I consider the easiest one, which is the seller listing contract. Let me grab it here real quick. So the seller listing contract, I'll go through what the changes are. I love this. So we did increase the font on this, so it's now 12-point font. At least it's not in caps, because you know how much that drives me crazy. But we had to add, and is fully negotiable. So in case you were wondering whether compensation is fully negotiable or not, I mean, apparently saying it's not set by law wasn't enough. Now we have and is fully negotiable, because that is a term in the NAR settlement that we had to put in here. All right, the biggest changes are all going to be around compensation, obviously. So we get to paragraph 7 of the seller listing contract. And this was redrafted really to try and figure out how to deal with the fact that this offer of compensation has gone away, and figuring out when compensation is owed. So a couple things. We changed the words from cooperative broker to buyer brokerage firm to try and be consistent with how the terminology has evolved anyway. So that just is an update. For some reason, commission is a bad word now. So I don't know why, but you'll see throughout here, I'm just looking down here, compensation instead of commission. AG, for some reason, thought that it needed to be changed to compensation. So it's changed to compensation. 7.1, the amount, this was updated. It says, in consideration of the services to be performed by broker, seller agrees to pay brokerage firm as follows. We have 7.1.1, which is sale compensation, and it's blank percent of the gross purchase price or blank in US dollars. And then we have 7.1.1 that says, if buyer's brokerage firm A procures a buyer, or I guess I should say 1, procures a buyer, and 2, the transaction results in a closing of the sale of the property to such buyer, seller's brokerage firm may enter into a compensation agreement with the buyer's brokerage firm to contribute from the sale compensation amount of blank percent of the gross purchase price or blank dollars in US dollars to the buyer brokerage firm. So obviously we have the amount in 7.1.1 is the full amount of the commission, which includes any amount of compensation you're offering to a buyer broker. What I expect some people may do is that they may take the approach of, okay, well, maybe we don't want to offer anything to a buyer broker, which obviously that's one of the big things that came out of the NAR settlement, as well as the antitrust lawsuits and the DOJ, is that sellers should have that ability. What I want to warn listing brokers about is that whatever amount you put in there is what you're working for. So if you put in a minimal amount in this and say we're not offering anything to buyer brokers, and then you have a customer come in, you're working for the minimal amount for both sides of the transaction. So when you're deciding the amount of compensation that you should be paid on these listing contracts, make sure that you're being compensated for the full gamut of how you might be acting in the transaction, whether you're acting as a transaction broker for both parties, whether you're acting just as a seller agent and somebody else is representing the buyer, or whether you're acting as a seller agent and treating the buyer as a customer. You want to think through all of that before you decide what the amount is that you want to charge in 7.1. 7.1.1.2 was added because of something we did with the contract to buy and sell. We're going to get there in a minute. Contract to buy and sell has another provision we've added. It's called paragraph 29. It used to be additional provisions. Additional provisions is now paragraph 30. But 29 has compensation to the buyer broker. And obviously, without having this offer of compensation in the MLS, what we're going to see is more negotiation of the commission in the contract. And so what the Forms Committee did is they went ahead and put the buyer broker compensation in the contract. But you can see if the seller is obligated to pay compensation under the contract, it would be unfair for the seller to have to pay that under the contract and then also still have to pay the full compensation under 711 because the seller broker never entered into a compensation agreement with the buyer's broker. And so 7112 is meant to address that problem there of saying, hey, seller shouldn't have to pay twice, essentially. And so what it says, if seller agrees to pay the buyer's brokerage firm pursuant to the contract between buyer and seller, seller's compensation to seller's brokerage firm, which means the full amount in 711, will be reduced by the amount not to exceed the buyer brokerage firm compensation set forth in 7111. So what it's saying is this, is if you have an amount in 711 that says I'm getting X, I'm contributing Y, well, Y is being deducted if the seller paid that amount to the buyer broker under the contract. In other words, listing brokers shouldn't get to collect the buyer broker's commission just because the buyer broker negotiated in the contract for the seller to pay instead. I'm going to pause for a second and talk about, I know that if you looked at the aggregate of things, you can make the argument that the seller always pays commission regardless. You can make the argument the buyer always pays commission. But I want you guys to see there's a legal distinction between who's paying commission. Under the listing contract, the legal distinction is if the listing brokerage firm is offering the compensation, then they're paying it out of their bucket. If it's in the contract that the seller will pay, then the seller's paying it out of their bucket. And if the buyer is electing to pay it under the contract, then it's coming out of the buyer's bucket, even though ultimately it all comes from a buyer's loan and everything else. So while it's confusing, you need to keep that separated to understand how all these components work. Okay? But 7112 is essentially saying if you put it in the contract that the seller's paying it, then the seller's compensate or the listing broker's compensation is going to be reduced up to the amount in 7111 that the seller was going to offer to a buyer broker. Okay, I'm sure that's clear as mud, honey, but there you go. Maybe people can listen to it like 17 times.
We did have a couple comments that they were a bit confused on that. So,
okay,
guys,
well, I'm just trying to, I guess I'll try one more time because I know that it's confusing. So I want you to think about it this way. Okay, you have a bucket over here that has 10 apples. Okay, and you decide, you know what? I'm going to take 7 apples out of here and give it to somebody else if they bring a buyer and everything else. But then the contract comes in and it says that the seller is going to pay 4 apples for the buyer broker. Then the commission over here for 10 apples needs to be reduced by 4. And I'm hoping that makes sense. And I'm trying, guys, I'm not trying to talk about commissions or anything else. That's why I'm talking about apples. So don't equate this to anything because it's not meant to be. I'm just trying to show you how these buckets work, that if you have a bucket on your listing contract that includes buyer compensation and the seller pays for it through another mechanism like the contract, then yours is going to be reduced up to the amount that you were going to offer a buyer broker. Hopefully that's a little clearer. Okay. Yeah, so that was the easy one. And that's really all the changes that are in here. You see they changed compensation throughout, but that's really about it. Okay, so let's go to the harder ones because this is working out so well.
how about them apples?
How about them apples? Okay, so the next one I'm going to talk about is the buyer listing contract. Again, fully negotiable had to be in here. One of the changes from the NAR settlement, and this is going to screw a whole bunch of people up. It says that you cannot receive any more than what you have specified in your contract with your buyer. Okay, now I want you to think about that. You cannot receive any more than what you specified in your contract. So if the seller is offering X, which is, or is offering, if you are putting your buyer listing contract, you're willing to work for X, and the seller is offering X plus 2, you don't get the 2. Okay? Now, you guys can amend the contract and the buyer can agree to it, but one thing I want to warn you about is that if I'm a buyer and you come to me and say, hey, I know I said I would do this for X, but you know, the seller is offering X plus 2, and I'd like to get the plus 2, unless they're like a really good friend or somebody you know very well, don't you think the buyer's going to say, hey, wait a minute, why would I give that to you? Shouldn't it go to me? Or, well, why don't we split it? Or maybe you could have the seller pay me seller concessions instead. So the biggest thing I want you to hear from me on this is that whatever you're going to put in your buyer listing contract, make sure it is adequate to compensate you properly for the services that you provide, period. The amount you put in here has to be adequate to compensate you for the services you provide, as if you're never going to get anything else. Because what the settlement said is that you can't ask for more, or you can't receive more unless you, obviously, if you amend it, you could, but you can't receive more. So you can see, I'm sharing this, right?
Yes.
Okay, let me pull this up so I can show it so that people can actually read it, because that was a little small. So in paragraph 7, what it says here is we took out the language that originally said brokerage firm is entitled to receive additional compensation, bonuses, incentives paid by listing brokerage firm or seller. Well, it's not. It says, unless approved by buyer in writing, brokerage firm is not entitled to receive additional compensation, bonuses, incentives paid by listing brokerage firm or seller. So you can't receive them. So that's over, and you're going to have to learn to deal with that. If there's more to be paid, you're going to have to talk to your buyer and figure out what you do with it. Like I said, you can't amend the contract, but I would make sure that when you're filling this out in the success fee of 7,111, that you're starting from a number that if you got paid that and that's all you got paid, you're happy with it. Because if you think you're going to go collect more later, you're probably going to be mistaken. All right. One other thing I want to point out is that if you have a listing contract that's in place after August 17th, and you put in the amount, I used to see people put TBD. Please don't do that. Or if you're putting in a range or anything that is not definitive, that is a problem under the NAR settlement. Frankly, you shouldn't have been doing it to begin with because it was bad practice. But it is a violation under the NAR settlement because TBD is not a definitive number. Okay? You have to comply with the NAR settlement for that part. And I guess I'm going to talk about the NAR settlement here in a minute, honey, but don't let me forget to do that before we go on to the next form, okay?
Okay.
But so if you have to, make sure you're amending these contracts to put in a definitive amount. If you don't have something in there. The other thing I'll point out is that on 7th, so this is a big change, and frankly, I think it's the best change of all the forms, is 7.3, who will pay brokerage firm success fee? And so you've seen this one before. It says seller's brokerage firm, seller may pay, buyer is obligated to pay. And we have before buyer will pay. But I want you to see 733 is dead. Gone, kaput, out. 733, if you'll remember, was the one that said listing brokerage firm or seller may pay, buyer is not obligated to pay. That is gone. And the reason obviously is because before, the reason we had it is because we had the offer of compensation, which meant we weren't going to obligate the buyer to pay more than what the seller was offering. But now that the offer of compensation isn't a part of our world anymore, then it's gone, because the only way buyer brokers get paid is if they have a contract. So if you have an agreement right now that has 733 checked, you're going to have to amend that one too, because if you have something that says buyer is not obligated to pay, I don't think you can collect commission, because the settlement says that you can't collect any more than what you agreed, than what the buyer agreed to pay you. And if the buyer didn't agree to pay you anything because you checked 733, then I think you're working for free or in violation of the NAR settlement. So that's another thing that you might look at if you have to change. But obviously, moving forward, at least it's no longer an option. They took that out, obviously, to make sure that brokers are getting paid. And I think it makes it a lot easier to get these things signed, because now that you only have two options, hey, buyer, I got two options for you. You can either pay my commission, or I can ask the seller or the seller's brokerage firm to pay it, and you only have to make up the difference. What do you want to do? And I think that's pretty obvious as to what most buyers are going to choose. That's it on this form. I did want to talk about the NAR settlement, because I should have said this at the beginning, but I didn't. I want to point out that the NAR settlement And this becomes important with our next form. The NAR settlement is not Colorado law. Okay. It is a settlement over antitrust disputes that involve realtors and MLS participants. Now, because it's MLS participants, it pretty much drags in most of the residential market to deal with this, but that is who it applies to. And we're going to talk about that with our next form as far as why that is important. So the next form we're looking at is the brokerage disclosure to buyer. So the brokerage disclosure to buyer is a form that you guys should have been using already. It's required by the Division of Real Estate. Division of Real Estate says you have to use this form prior to receiving any confidential information from a buyer. It should be in every single one of your files unless you're doing buyer listing contracts at the first meeting. And what it's for is defining your working relationship with your client up front to say you're either acting as a transaction broker or you're treating them as a customer. Those are the only two options under this form. Buyer agent isn't available under this form because this is not a contract. If you want to be an agent, you got to do a buyer listing contract. But it's something that's been used for a long time. And what the Division of Real Estate said was that apparently brokers don't use this form all the time that they're supposed to. And so when we started talking about the fact that, there are clients that do not want to sign buyer listing contracts immediately. And if you've heard Marsha Waters talk, I'm sure you've heard her say that on Colorado, you do not have to sign a contract in order to show property. Okay, a buyer does not have to sign a contract in order to show property. In fact, it goes back to the fact that Marsha Waters thinks that the NAR settlement is, as far as, what I'm talking about is the NAR settlement has a provision that says in order for you to tour property, the buyer has to sign a compensation agreement. And there's a rub here. And the rub is that we have NAR saying, oh, all MLSs, you have to enforce this. And we have the Division of Real Estate saying, no, not in Colorado. I'm going to tell every buyer that calls that they do not have to sign an agreement to go see property that is not real estate brokerage activity. So you can see the rub here. Because there's a rub, I'm going to talk about it here in a minute, but I don't think it matters that there's a rub. But what I want you to see is that you can't tell your clients, oh, you have to sign a compensation agreement or a buyer listing contract. And so when you work with a client and you have somebody that says, hey, I don't want to sign a buyer listing contract, I don't want to sign a contract, that's fine. That's when you would use the broker's disclosure to buyer. And we go through this and you see it has the transaction broker, buyer, seller agent, buyer's agent, customer. This form should be familiar to you guys, but what happened with the Forms Committee, what the commission approved is now on the back side of this form is a brand new form. And it's called Buyer's Broker's Compensation Agreement. And what this is this is the compensation agreement that I think probably meets the requirements of the NAR settlement. But again, it can't be required. Okay, you can't say that state law requires people to sign this. You can't say, you can say that the NAR settlement requires it, but I don't know as it's applicable in Colorado. So I want to make sure that we're clear on this. But let's go through this form and then I'll tell you how to use this form in the buyer listing contract as well. So what this talks about is compensations charged by, so we have this in here because obviously the settlement agreement requires it. Compensation charged by brokerage firms is not set by law and is fully negotiable. And then the first paragraph says this: in consideration of the services to be performed by buyer's broker as buyer's transaction broker, buyer's broker's brokerage firm will be paid a fee equal to blank percent of the purchase price or blank dollars, which is the success fee, with no discount or allowance for any efforts made by buyer or any other person. Unless approved by buyer in writing, brokerage firm is not entitled to receive additional compensation, bonuses, incentives paid by listing brokerage firm or seller. So what this says is a couple things. Number one, I want you to notice this is only for transaction brokers. You represent the seller. Customer comes in. You give them the first form up here, the broker's disclosure to buyer, and say, hey, I'm checking the box that says I'm treating you as a customer. No compensation agreement. Okay, because it only applies if you're acting as a transaction broker. Now, what I expect people will say is, well, wait a minute, my listing contract is low, and if I'm doing both sides of the deal, I really think I'm entitled to more commission. So what I'm going to do is convert to transaction broker and do the compensation agreement. Does everybody see where that's a problem? Hey, seller, I don't think you're paying me enough. So what I did is I decided to act as transaction broker in this deal so that I could be neutral and stop being your fiduciary. I just want to warn you guys against trying to use this compensation agreement to change to transaction broker to pick up more commission. It's not good. It looks bad. Seller's going to have a heyday with you if you go sideways. So I would not do that. Again, it goes back to what I talked about in the seller listing contract, is making sure that you're putting in the amount that you are willing to work for, regardless of what that transaction looks like, whether you're a transaction broker for both sides, whether you're an agent for the seller, whether you're an agent and have a customer that's purchasing the property. Okay. No discounts. Obviously, you can't receive additional compensation without. So if you are a transaction broker, because you pick somebody up that says, I don't want to sign anything, but I want to do a compensation agreement, you can still do that. You can be transaction broker. Check the box up top that says you're transaction broker. It could be one of these two. And you move forward. And as you do that, sorry, I had a call coming in and confused me. You can't receive additional compensation again. You can't really amend this unless you get something in writing from the buyer saying, I'm okay with you receiving more. But you can't receive, if they're offering X plus 2 and you did this for X, you can't receive plus 2. Same concepts as the NAR settlement when we're talking the other contracts. Next paragraph. The success fee is earned by brokerage firm upon buyer's broker performing services that result in buyer entering into a contract to purchase property acceptable to buyer and is payable upon closing of the transaction. Success fee is earned by brokerage firm upon buyer's broker performing services that result in buyer entering into a contract. I don't think showings is going to do it, guys. Showings is not, as Marshall Waters has said several times, showings is not a real estate broker activity. So what I see, some shortcomings I see with this form, and while I think it's a good form as a stopgap, what I see some shortages in this form is that you have a buyer who wants to look at property. You say, okay, let's go look at property. You show them 30 homes. And then they go and they say, oh, well, I'm going to go write on a contract with my cousin. I don't think you perform services that obligate that buyer to now pay you. So you can see where this language kind of means that you got to follow them through the contract. You got to write the contract and be involved so that you can show that you did the services in order to earn that commission. I also see buyers entering into several of these because you'll notice that there's no real end to this, but the limitation on this is who's providing the services. And that's where the fight's going to be over, is who provided the services that earned the commission. It's kind of like procuring cause, but I'm not sure it's quite there. If any transaction fails to close as a result of the seller's default with no fault on the part of the buyer, the success fee will be waived. If any transaction fails to close as a result of the buyer's default in whole or part, the success fee will not be waived. Such fee is due and payable upon buyer's default, but not later than the date that the closing of the transaction was to have occurred. So if buyer defaults, you still get your money. Broker is authorized and instructed to request payment of the success fee from one or both of the following: the seller's brokerage firm or the seller. Obviously, we want to make sure that if you have a buyer that is transaction broker, that they have the ability to ask for it in the contract, which we'll see here shortly as to why that's important. By the way, you can't ask for it in the contract unless the buyer has some obligation to pay you. So again, 7.3 is checked in your listing contracts right now. You're going to have to get those amended. Buyer is obligated to pay any portion of success fee which is not paid by the seller's brokerage firm or seller, but only if broker discloses to buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller. And this is also in the buyer listing contract, which essentially says this, is that if you enter into a contract and your buyer has agreed to pay you X plus 2, and the seller agrees to pay you X, or the listing brokerage firm agrees to pay you X, you can't ask your buyer for the plus 2 unless you have disclosed that prior to them signing the contract. Okay? In other words, any difference that the buyer has to make up, they need to know about it before they're obligated under the contract. And that's whether it's a buyer listing contract or under this brokerage, under this compensation agreement. And the purpose of that is you can see where that would be unfair to a buyer. You know, you have agreement for X plus 2. They end up negotiating a contract. Compensation agreement says that the buyer broker is only getting X, and then we're under contract. And the day before closing, the buyer broker comes up and says, "Oh, hey, I was looking everything over, and I just noticed you still owe me plus 2. I'm sorry about that. I forgot to tell you, but that's what our contract is. So you got to pay us the plus 2." That would be a problem. And so in both the buyer listing contract, which obviously I skipped over that and didn't mean to, my apologies, and in this one, you have to tell them about it ahead of time. Otherwise, you're not going to collect the plus 2. You're only working for what the compensation is in there. Okay, so I want to talk about the use of these forms, because you can see, first of all, I will tell you, I'd rather you guys get buyer listing contracts. Okay, so the first thing I'll tell you is this, is that even though we talked about how you can't say that, oh, Colorado law requires you to sign one of these agreements, you can't say NAR settlement requires you to sign one of these agreements, because the NAR settlement really isn't law. That's an MLS policy and rules that are obligating MLS participants. And it's not, and there's a real open question here now as to whether or not it's even acceptable in Colorado. I will tell you, our regulator does not think it's allowed in Colorado. She has been very firm about the fact that she thinks that requiring this to be signed prior to touring any properties is contrary to Colorado law. However, there is nothing wrong with a broker having a policy that says, I don't work for free. So while Colorado law may say, and this is where I say that I'm not sure it matters whether Colorado law applies or doesn't apply. It's just about your vernacular when you're talking to people about what you're saying, is that to me, it's about your policy. And if I'm a broker and I'm working with buyers, I think I would make it clear to them that, look, when we, before the NAR settlement and before the antitrust lawsuits, what we had was an offer of compensation. It was a great system. Seller would put up an offer of compensation for an amount, and some buyer brokers would say, you know what, regardless of what they're offering, I'm okay working for that. And they would do that, and they wouldn't obligate their buyer to pay anything. But now we have the system where the offer of compensation is out, and the only way that I can get paid is if I have an agreement with you to pay some portion of fee. And so it'd be unfair to me to ask me to go show you property, knowing that if I show you the property and you end up executing a contract and everything without a compensation agreement, I'm literally working for free. Because if I'm your transaction broker, because I entered into a relationship, but I don't have a compensation agreement, that means I'm literally working for free. Does everybody see how that's a problem? So there's not a problem with a broker saying, my policy is that before I start working with a client, I require a compensation agreement. And the reason I do that is because I don't have the security or the safety net of the offer of compensation in the MLS anymore. And I need to know that if I'm going to go out and spend time with you and show you a bunch of homes and work with you, that if I'm successful in helping you find a property, that I'm going to get paid for it. That to me is what this is all about. And I think what's lost in the noise is the fact that this is really a policy that brokers should really be considering having for themselves about how their livelihood works. Now, you got two choices in compensation agreements with the buyer. And for me, what I would probably do is present it as, well, buyer, we have two options. I know you don't want to sign an agreement, and that's fine. I completely understand that. We can go with this buyer listing or we can go with this broker disclosure to buyer. Broker disclosure to buyer says I'm treating you as a transaction broker. It says I don't owe you any fiduciary duties. It says I don't have to advocate for you. What it essentially says is that you owe me if I'm successful helping you enter into a contract. But there's no real obligations on my part to really be your fiduciary. In fact, I'm not your fiduciary because I'm not your agent. or you can sign a buyer listing contract where I am a fiduciary and I represent your best interest. Which one do you want to sign? You're going to pay me either way. Do you want me as your advocate or not? And I think that's a way to maybe start getting those buyer listing contracts signed by buyers earlier on in the process. One of the big problems we've had in our industry is a lot of buyer broker or buyer listing contracts weren't being signed early anyways. And that's a problem, guys. It wasn't good practice to start with. You're going to have to be diligent about getting these agreements signed ahead of time. And if your policy is that, look, I don't go out and show properties without having a compensation agreement in place, then you need to make sure that you do it for everybody. What I mean by that is that if you make an exception, you could find yourself subject to some kind of fair housing claim where somebody says, well, you made an exception for them, but you didn't make an exception for me because I'm gay. That's, I think, going to be a problem. So, make sure that if you're setting that policy that you're doing it for everybody, and you can use either one of the forms, just understand the limitations of both of them as you're moving forward. All right. How am I doing, honey?
You're doing great.
Any questions so far? I mean, I see we have like 3 hands up and
only a few dozen. Hey, speaking of questions, if you guys don't mind doing me a favor, hop over to the Q&A. And if there's questions on there that you all would like to see answered, you can upvote. So give a thumbs up to the questions that you want to hear answers to. That'll help me kind of sift through which ones to address.
yeah, and we're not going to be able to get to all of them. As you guys can tell, I haven't got through the last contract and we're 12 minutes away from the hour. So my apologies. Like I said, there, you can tell from what we've already talked about, there are so many nuances and the language and everything. It's just, there's so much to this, guys. I just really, really, really want to encourage you to take I don't think you can hear this too many times. And I know that sounds silly, but I think the more you hear this, the more you're going to get different things out of it and different things that you hadn't thought about before to figure out how to incorporate it into your business and how to make it work. And frankly, like I also said, once these go in place, there's going to be things that I never anticipated happening just because that's the nature of real estate brokers. You guys are so freaking creative. It drives me crazy at times. I'm not going to lie, but you're very creative. And all of a sudden you come up with something like, I did not see that coming. Sometimes it's good. Sometimes it makes me want to blow my brains out. But I'm just kidding, honey. I'm just kidding. But I just, keeping up with this and just kind of going through it over and over again and reading the top contracts and understanding the documents and really parsing them out is going to be helpful. And for your broker associates, spend some time with your employing brokers, go to the sales meetings, talk to your trainers. It's just going to help you guys as we work through this because it is going to be a major shift in our industry. And what I foresee happening is a lot of buyer brokers working for free. One of the questions I keep getting over and over again before I go to the last form is that if you work for free, does that mean you don't have E&O insurance? And the answer is I don't know. I asked Marsha Waters that about the Rice program. She says that she talked to Rice, and Rice says that a commission is not required to have coverage. I don't know. I don't always trust insurance companies, but that's at least what they're saying. I know that some of the policies don't have a carve out for it, but I know that some of the franchisors and some of the national people, NAR, and some of those are talking about it. So obviously there are insurance companies that do have that carve out to say that if you were working for free, it's not a real estate brokerage service. Therefore, there's no coverage. Make sure you check your E&O insurance. I don't think it's going to be an issue here, but I'd rather you guys check and make sure. Okay. All right. So the last form I want to talk about, and I'm not going to talk about all of it because there's a lot of changes to this. Like I said, before the NAR settlement hit, the Forms Committee was working on changes to the contract to buy and sell. So to give you some idea, you can see there's a whole bunch of contract changes here, all the way throughout the form. But the only one I'm going to talk about because it's related to NAR is going to be paragraph 29. And frankly, I feel like Colorado has addressed the NAR settlement very, very well. And for the most part, a lot of the things that were complained about and a lot of the practice changes that were put in place under the settlement, guys, we were already doing. I mean, we were already training, don't check 733 and that you should check the box that the buyer is obligated to pay. We're already training about putting commission in the contract if the amount offered wasn't sufficient to pay the buyer broker's commission. You know, we were already working through a lot of that stuff anyway. So for the most part, some of this stuff isn't different, but when you start looking at those new forms, there's some different language and some of the changes that you really need to be aware of so that you don't get caught in a gotcha. But paragraph 29, because obviously with the offer of compensation coming out and questions coming up about, you know, you can just totally see a buyer broker being like, hey, buyer, you want to buy this property? Yes, I do want to buy this property. Okay, let me see if they're offering compensation. Calling Jill and saying, hey, Jill, are you offering compensation? Crickets. Well, now what do I do? Well, I can either wait for Jill to get back to me, which I know this is hard to believe, but some listing brokers are just not very responsive. Or I can try and move the contract forward or figure out a way to look out for the best interest of my buyer. And my concern is if we end up in an area like the pandemic, that we had 40 offers on a property, I could see waiting for Jill to get back with me. And then I finally call her again. And she says, oh, gosh, I was so sorry I didn't call you. I meant to call you back, but we already went under contract. Well, did I not just breach my obligations to my buyer? So that's my concern with the compensation agreement, is that I think it's a good form. I think it's good to use it when it's easy. But if you are a buyer agent representing a buyer and your buyer is trying to make an offer on a very popular property and the seller listing broker is being non-responsive, or they want to get the offer in quickly hopefully before anybody else does, or something along those lines, paragraph 29 is a way to go, because remember, you have your buyer listing contract that says you're owed a commission, or you have that compensation agreement that says you're owed a commission. And with one of those, you can now fill out paragraph 29. And since compensation was going to end up in the contract, it's already ended up there several times because of past practices with the flat rate brokerage firms and the iBuyers and the for sale by owners. We were already seeing it in the contract, but now we have a provision that's drafted by the Division of Real Estate for your use. And what paragraph 29 says is this: it says, buyer's brokerage firm compensation. Buyer's brokerage firm's compensation will be paid at closing as follows. There's three options. Okay, check boxes on each one. 29.1 says blank percent of purchase price or blank by seller. Buyer's brokerage firm is an intended third-party beneficiary under this provision only. The amount paid by seller under this provision is in addition to any other amount seller is paying on behalf of buyer elsewhere in this contract. Okay, so let's parcel this out a couple ways. So first of all, this is where we say the seller's paying it on behalf of the buyer. The reason the buyer's brokerage firm is an intended third-party beneficiary is this: seller agrees under the contract to pay the buyer's obligation. We get to closing, and the seller says, I'm not paying it. Sue me. The problem is that the buyer broker's claim is against the buyer, because that's who our contract is with. We don't have any privy of contract with the seller, and we aren't a party to this contract either. So the only way for the buyer brokerage firm to have a claim against the seller directly is if we are a third-party beneficiary. And so that's why that language is in there, to give the buyer brokerage firm standing to go ahead and sue the seller if for some reason the seller balks on paying the buyer broker's commission. And so we don't have to bring our buyer broker into a lawsuit unnecessarily. The second one is this: the amount paid by seller under this provision is in addition to any other amount seller is paying on behalf of buyer elsewhere in the contract. That is in there because if you have seller concessions, do you see how, oh, well, I'm already paying seller concessions, so I don't have to pay all that in the brokerage firm compensation. Wanted to make it, oh, I'm paying for FHA and VA. Sorry, that gets taken off of this. No, it doesn't. We wanted this to stand alone as far as the compensation is concerned. One of the things that the NAR settlement also talked about was seller concessions. And it said that seller concessions could include commission. It doesn't work. I'm just going to tell you, I would not lump seller concessions and commission together. First of all, it doesn't work for the lenders. The lenders like to see those separated. When they have limits on seller concessions, it's in addition to any compensation that's being paid. So if you add seller concessions and then you put in compensate, or you add the compensation in seller concessions, it's going to exceed the limits in which the lender can pay. Additionally, you have this problem of, what happens if you offer seller concessions, then you have to offer it to every buyer, whether they have compensation. It was a mess, and it doesn't make sense, and it doesn't work. So even though this NAR settlement talks about being able to do that, I would just forget that that was ever a thing. Okay. Section 29.2, another checkbox, blank percent of the purchase price or blank by buyer pursuant to a separate agreement between buyer and buyer's brokerage firm. Okay, what's the separate agreement? Buyer listing contract or the compensation agreement? Okay, you have to have it because you can't put it in the contract unless you have one of those. This amount may be modified between buyer and buyer's brokerage firm outside of this contract. That was actually an addition by Marshall Waters. It was a good point. What she said is this: it said, what happens if the buyer broker says, hey, I'm willing to give up $500 to make this deal go? We're at an impasse on inspection, and it's $500 to fix a window that the seller's refusing to pay, and the buyer says, I'm not moving forward unless I get it fixed. The buyer broker should be able to waive that portion of their commission separately in order to make the deal work. And so because it's under the separate agreement with the buyer, so if the buyer is making this agreement that says I owe you X, then the broker can say, okay, well, let's do an amend extend, a listing contract amend extend. We'll reduce my commission by $500 for this transaction, just so we can get this thing to work. And they should be able to do it separately without having the seller sign off. Because you can see if the seller is getting cold feet, trying to get out of the transaction, the last thing you want is to have to negotiate something in the contract that doesn't even impact the seller that they could say no to. So that's why that provision is in there. And then the third one is 29.3, which is blank percent of the purchase price or blank by a separate agreement between buyer's brokerage firm and seller's brokerage firm. Well, what's that? That's the brokerage firm compensation agreement from the Bar Association that we talked about. Now, what's interesting, what I like about this paragraph is that you don't just have to check one box. You could check all three. Seller is paying X, buyer is paying Y, and we got a compensation agreement for Z. And that adds up to what I was originally asking for, which was AA. I'm using random letters now. So you can see how this could be, it could mix and match, and you could put it in there. The one thing I don't like about paragraph 29, and there's just no way really around it, is that it is going to put the buyer's brokerage firm commission into play as far as the negotiations of the contract. There's just no way around that. Because of the offer of compensation going away, it's just going to be part of the negotiations. And buyer brokers, you're going to have conversations with your buyers about the fact that they have this obligation that if the seller and the listing broker are not willing to pay it, they counter and say, nope, seller's not paying it. You're going to have a hard conversation with them about the fact that they owe it. To me, the easier part of that conversation is to say, look, buyer, when they did the comps are all based on what the market value is in the neighborhood. Every neighborhood is different, but most neighborhoods have the sales price, and the sales price typically includes compensation, not only to the listing broker, but in most cases also to the buyer broker. If the seller is unwilling to pay my compensation, and yet their purchase price is at the comparable rates and they want the fair market value, that really means you're overpaying for the property. That's what that means. And buyer brokers, you're just going to have to get comfortable having that hard conversation with your buyers about the fact, because they're going to be in love with the house and they want it, and they're saying, well, wait a minute, can't you take a haircut on your commission? Come up with having some talking points and some scripts and things to help them understand that, number one, you work for a living, you should get what you contracted for, and number two, probably overpaying for the property. Okay, so that is all of the contract provisions that changed due to the NAR settlement. So I know that we have some questions in the Q&A. Honey, do you want to try and get through a couple of these? Oh my God, 60? Okay.
Yep, we did an upvote, so we're just going to try to tackle as many questions as we can. So first question, if we have an exclusive right to sell or exclusive right to buy in effect, do we need to amend extend after 8/17 to include the changes, or just do a new agreement on the new forms?
So I'll tell you, I hate doing new contracts. I don't like giving parties an opportunity to say, no, they don't want to sign something new. But if you have a buyer listing contract that has a range, has TVD, has 733 checked, you're either going to have to do a new form or you're going to have to do an amendment. With the seller listing contract, nothing really changes. I don't know why you would have to do an amendment on that. And I'm trying to think of instances, anything in there that would change that. But I don't think that would change anything because you still have the offer of compensation. It's not going in the MLS, but you can still do compensation agreement between brokerage firms with it. So I think that one would probably be fine. It's just the buyer listing contract, you're going to have to do something different if you have one of those fatal flaws. Um, because it was entered into before the settlement agreement went into place, it's not a violation of the NAR settlement to have clauses in there that aren't compliant. It's only for things that are entered into after that. But I do think you need to amend those provisions if you have fatal flaws for how you get paid. Again, I want to remind you guys that the NAR settlement is just for MLS participants, and which includes most of you because I don't know how you do business without an MLS participation, but I still think a lot of the stuff in here makes sense, and I think it's about having a policy of getting compensation. So yes, I would look at your agreements and make sure that there's no fatal flaw for how you get paid. And the buyer listing contracts are going to be the ones that are the worst.
Pam asked, I thought that compensation could not be between brokerage firms, that the compensation had to come directly from the seller to the buyer broker if negotiated.
Nope, that's not true. What the agreement says is that it can't be an offer of compensation in the MLS. Now, the DOJ has said that they have, I'll say, trepidation about listing brokers paying buyer brokers. But at this time, that's just talk, and it's been things that they've said in press conferences and things. There's no official position on that. There's no case law or any kind of pending matter with the DOJ or anything else. And they haven't interceded in the NAR settlement, which doesn't require it either. So at this point, that is not something. DOJ has talked about it, but at this point, it's still there. If that ends up being the case, then obviously we'll update the forms. But I'm not sure that the DOJ is going to be able to. I don't know. I'll be surprised if that ends up being the case, but I guess we'll see.
What if the exclusive right to sell says that the seller agrees to pay X amount, but buyer's agent submits a contract for less? Is the seller obligated to pay the higher amount?
Well, so the seller's not obligated to pay the higher amount, but the difference would go to the listing broker. Because remember, it starts out with they submit one for X, you have it for Y that you were offering them. Or I'll say X plus 2 is what you were offering, and they submit it for X. The plus 2 actually goes to the listing brokerage firm because it's the full amount of the commission, including the amount offered to the co-op broker, that is the listing broker's commission. And if the buyer broker brings an agreement that is for less and you don't have a compensation agreement with the buyer brokerage firm, then the listing broker gets the difference. Now, if you want to talk to your client about what happens with that or do something different, you certainly can do that and agree to something different. But under our contracts, that's what happens is the additional goes to the listing brokerage firm.
Okay, if I write a contract before August 17th, but that will close post August 17th, do I need to write into the current contract in the additional provisions, the compensation, what the compensation will be? I assume it will be wiped from MLS on the 17th, so I won't have proof it was there. Thoughts?
I would, if you're writing a contract prior to August 17th, I would make sure you print out the MLS sheet that shows the amount of your offer of compensation. Technically, I don't think you need to have it in your contract because it is an offer of compensation. Commissions are earned when things go under contract. And so if you went under contract prior to August 17th, then you did earn the offer of compensation that was in the MLS. But if you wanted to be safe with a belt and suspenders approach, then you certainly could build it into the contract and make it crystal clear. But technically, I don't think you need to.
Why can't we put this in the offer? Seems simpler.
I don't have a problem with it being in the offer. That's why this is here. As far as the offer in the buyer brokerage firm compensation. I won't be surprised if we start seeing this used more than brokerage firm compensation agreements or but I think that our industry, one of the things that's being challenged right now is that so CAR which is the California Association of Realtors, they have a lot of forms, and theirs are drafted by the Association of Realtors and not drafted by the Division of Real Estate out there. And right now, the DOJ is scrutinizing them as well as some other public interest groups or whatever you want to call them. And part of the issue that they're having is that they're talking about putting stuff in there like, hey, the broker doesn't have to show the property unless there's an offer of compensation. And the only reason first of all, I think that's a terrible practice. For the love of God, do not do that. I mean, how do you justify that to the Division of Real Estate that you didn't perform your fiduciary duties or your minimum duties if you're just a transaction broker because they weren't offering compensation? That's been a problem for a long time, and it remains a problem now. But the point is that a lot of our industry just wants to keep that compensation because it's been that way for decades, generations, and it's hard to let go of a system that worked for us. And I think that we can hold on to that system, at least in part, by having those compensation agreements. But I do think that we're going to see more of it end up in the contracts. And I don't know if it'll go away or not entirely. But, if the DOJ comes in and says listing brokers offering compensation to buyer brokers is a no-no, then it will be in the contract.
Does the title company organize and distribute the compensation? Is it on the settlement sheet?
Well, I'll tell you that's the one byproduct of this that I think is really, really good is that, in the past, we had these offers of compensation that were in the MLS. And to be honest, I'm not even sure that the title company ever checked the MLS to find out if the offer, what they were told by the listing broker, matched up with the MLS. I've had several cases in the past where they wrote in the contract the buyer broker was getting something different. Listing broker said, no, they're getting this. They didn't disclose the seller's settlement statements to the buyer broker. And after closing, buyer broker gets their commission and says, hey, wait a minute, this is light. It doesn't match the contract. And I think some title companies may have paid out on that. But my point is that this is a lot cleaner because it's in one place in the contract that I think it's going to make it a lot easier for the title companies to know how much compensation the buyer brokers are actually going to receive because it's in paragraph 29 every single time, and you have 3 boxes as to who's paying what amount. So it makes it very easy for them to put it on the settlement statements, whether it's the buyer settlement statement because the buyer is paying it, or it's the seller's settlement statement because the listing broker or the seller is paying it. So I think that might actually be better than what we had before. I'd love to figure out how we put in there what the seller is paying the seller's broker, but that's a little too hard because buyers are the ones that submit offers. So anyways, I think that's actually going to be better for our industry having it in the contract that way.
Here's a question. I feel like you answered this, but I'm reading at the same time. So if you ask for the maximum compensation, can you accept less?
So let's say you ask for X and the seller says, sorry, I'm only paying X minus 2. I'm not sure what this is asking with the maximum compensation, what that means, but I'm just going to assume that it means I asked for X. Seller is saying, I'm only offering X minus 2. Yeah, you can go to your buyer and say, you know what? Technically, under our agreement, you would owe me 2. But you know what? I want you to get the house. I'm going to waive that. In fact, I'll send you an email that says I'm waiving anything in excess of what the seller is in excess of X minus 2. I'm waiving the 2 because I want you to get the house. And that's why I'm saying when you guys are deciding how much you're working for under your engagements, whether it's a buyer listing contract, seller listing contract, or now the new compensation agreement, make sure it's for the amount that you want to work for under all circumstances. You can always go backwards, but getting more is a lot more difficult. And you need to know your value, guys. And I think we beat that drum for about 2 years, at least Scott Peterson and I have. So figure that out. Make sure you can have those hard conversations. I'm going to go on a rant now, honey, and go down a rabbit hole. But, when we take listings, when brokers take listings with sellers, you guys are very good about explaining how much compensation you're going to get paid. You're very good at getting a contract signed immediately upon going to the first time that you go see people. I mean, you're very good at doing that. We just have to have the same mentality and the same approach to buyer listing contracts now that we've applied towards seller listing contracts for generations.
So Kristen says, I took an ABR class recently. NAR taught that the compensation agreement could go from seller agent to buyer agent, seller to buyer agent, buyer to buyer agent, etc.
I think that covers everything that we just talked about in 29. So yeah, I agree.
On the new buyer agent contract, it states buyer is obligated to pay any portion of the success fee, which is not paid by the seller's brokerage firm or seller, but only if broker discloses to buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller. Negotiations with the seller haven't even started. So how do we know what that amount will be? How do we navigate this?
So my best approach would be this: if your buyer has agreed to pay you X and you're making an offer, and let's say that the listing broker hasn't contacted you, or they said that that there's no compensation offered, whatever it happens to be. What I would do, I'm going to pull up my form real quick because I like my form. Okay, so we have 29 here. What I would do is I'd put the full amount X in here by seller. Check the box, X by seller. And then the seller counters and says, no, it's X minus 2. Well, now we have to disclose to the buyer, you have an extra 2 here. So we're doing 2 in this. I don't know what, it's probably not percentage. It might be dollars. I don't know, whatever it is, the difference. But you see what I'm saying is that now you can come back and write another offer and just check this box and this box saying, okay, seller, you're paying this, what you agreed to, and my buyer's picking up the rest. That's a way to get there as far as that compensation is concerned, either with a counter proposal or with the contract itself. Or if, the listing broker says, hey, I just want to let you know, my seller's only willing to do X. If you want more than that, you're going to have your buyer pay it. Then when you make the offer, you could do the X in 29.1 and the 2 in 29.2. That's what this does. It gives you that flexibility to come up with that. But that is disclosure in the contract, because you're putting in the contract, for the love of God, make sure you go over it with your buyer and make sure that they understand what it says. Don't just put it in there and surprise them later. But that's the point of this, is that you're having that conversation at the time that you're going through this contract and saying, this is what it says. And then when they sign the contract, they know before they sign the contract. So that's really what that is about, is they need to know before they're bound under a contract that they're going to be obligated for something more than what the seller or the listing broker is paying. Likewise, by the way, 29.3, if the listing broker is paying it and the buyer's making up the difference, you might just check 29.2 and 29.3.
Okay, what happens if my listing agreement says my brokerage will collect a bunch of apples for an bunch of apples, and an offer comes in and is accepted, and 7.3.2 buyer will pay agent is selected. So if my brokerage no longer owes any apples, the buyer's brokerage, did I just get a ton of apples?
You just got a ton of apples. Offer comes in, buyer says they're paying the whole thing, then you get the full amount that you negotiate. Now, I expect a seller might be a little concerned about the fact that you made this commission that was supposed to go to buyer agents and it didn't go to buyer agents. So you might have a conversation with the seller and work something out. But under our agreements, that is what it says. You get the bunch of apples. If the buyer is paying the buyer broker everything, you get all the apples regardless of what the seller was offering to the buyer broker. And thank you for using a bunch of apples.
Okay, we'll get through a few more questions here. I know we're kind of quite a bit over time. How can we guarantee the buyer has the funds to pay us at closing? Should we require a bank statement?
I mean, I got to tell you, the way I see this mostly going is the fact that the buyer is going to ask you to negotiate with the seller and the listing broker. I mean, that's the way our industry works. It's the way it functions best. It's the way that Fannie Mae and Freddie Mac have allowed things for years. I think they're used to seeing it that way. Just so you guys know, VA, I'm sure most of you guys have already know this, VA has already changed their policy that says a buyer can now pay their buyer broker. But the reality is that the buyer in a VA situation probably isn't going to have the additional money to pay the buyer broker. I just think I would just tell the buyer, we're going to try and get it from them. And if we can't, then you're going to have to pay the difference. And if you get to closing and for some reason the buyer can't pay it, I guess at that point you talk to them about a promissory note or something. But I mean, I see most of these going the way of being negotiated, that the listing brokerage firm or the seller is going to pay it. That's what I really see, is that not much is going to change in our industry. And frankly, if you represent the seller, you really should be having conversations with the seller about the fact of, keep in mind, buyers don't have enough money to necessarily pay for a down payment and to pay their buyer broker. And so if you go in with the mentality that the buyer broker, or I'm sorry, the buyer is going to pay the buyer broker and you're not contributing anything, you will probably end up with less buyers able to buy your property because they're just not going to be able to come up with the cash to pay for a down payment as well as the buyer broker. You guys would know better than me, but from what I've seen, usually the limitation on buyers is not necessarily credit. It's usually their down payment, particularly with the prices as to where they've gone in our state. So that's where I see the problem being. And so, yeah, I think you could ask for a bank statement. I just wouldn't ask for, I wouldn't go down that road personally. But if you feel like you really want to know that you're working with somebody that is healed enough to pay it, if the seller or listing broker doesn't, then I guess you could ask for proof of funds. So there you go. How's that for a long-winded answer for a very short question?
Perfect. Can you address when listing firm is compensating, but seller also agrees to pay additional in the CBS? Then how does that work?
Okay, so the way that works, again, because apparently this was crystal clear the first time I taught it, is that if the seller is agreeing to pay for it in the contract, then the listing brokerage firm's commission gets reduced by the amount that the seller is contributing to the buyer broker up to the amount that was authorized to be offered to a buyer broker. Hopefully I did it better that time.
Okay, let's snag one more question here and wrap things up. Can sellers change their compensation in the listing agreement based on an actual buyer price received?
Okay, so this is a great question because this is where it's going to get really fun. Okay. I think a seller could negotiate what they're willing to pay. I mean, first of all, they can't really negotiate in the listing contract because that's your listing contract unless the seller's broker is willing to renegotiate their seller listing contract and change the amount of compensation they're willing to offer a buyer agent. Then that really can't be changed just because the seller wants to. The seller can always negotiate commission in the contract as long as it's not something that's in their listing contract already. Where I see problems coming up is that the seller listing contract says you're offering X. You make an offer of compensation of X to the buyer broker. Buyer comes in with a lowball offer. Seller says, well, I don't want to pay that much commission to the buyer broker. You're kind of stuck because remember, you got a brokerage firm compensation agreement with them. And you're either going to have to roll that back or get the buyer broker to agree to take less before you're going to be able to negotiate something different. Because right now you have an agreement already in place and that buyer brokerage firm does not have to agree to take less. So I tell the seller, you're kind of stuck with this amount unless, I can go back and tell the buyer broker, if you want to take less, then, we'll look at this offer, but I'm going to need something in writing from you saying that you're willing to take less. Because that's the only way I know how to negotiate that on behalf of the seller, because once the brokerage firm puts it out there, they're going to be obligated just like you would with any offer of compensation. The problem with our compensation agreement is that we don't have the flexibility of the MLS, which allowed you guys to change compensation or to change whether it was active or not in real time. Compensation agreement just doesn't get updated in real time like that.
Okay, great. I think we'll wrap things up there. Thanks everyone for staying late today, and we really appreciate your time. We hope that was helpful. I will be sending out a recording once I get that uploaded. So keep an eye out for that. I'll send some of the other documentation that we had talked about today. So, and also please think of Heritage Title if you have an upcoming listing that we could work with you on. Thank you all so much for being here. We'll see you next time.